Hello, my name is Chris Rootham. I'm a lawyer in the labor and employment law groups at Nelligan O'Brien Payne. In a previous video, my colleague Stephen Levitt spoke about an employee's right to notice, colloquially known as severance, which is the most common right exercised by an employee on their dismissal. But it is not the only right. I would like today to talk about three other rights that an employee has. First, the right to good faith. Second, a right to privacy. And third, a right to be free from misstatements by an employer. First, what is the right to good faith? The law in Canada imposes on an employer an obligation of good faith and fair dealing in the manner of dismissal. The law recognizes that employees are particularly vulnerable, both financially and emotionally, when they are dismissed. Therefore, employers owe an obligation of good faith to employees in the manner of dismissal. The right to good faith includes treating employees with respect and courtesy, no hardball tactics, and being honest with employees and with other people about why the employee was let go. If an employer acts in bad faith in the manner of dismissal, the employee may have a claim if he or she has suffered damages, typically in one of two ways. First, if the employee has suffered mental distress supported by medical evidence, or second, if the employee has suffered a damage to their reputation. Second, employees have a right to privacy. Federally regulated employees, as well as employees in British Columbia, Alberta, and Quebec, have legislation protecting their privacy interests. Employees in Ontario are not so fortunate. However, the law recognizes that employees have a reasonable expectation of privacy in the workplace. In Ontario, this manifests itself as a tort called intrusion upon seclusion, which is a category of privacy right with three elements. First, there has to be intentional or reckless conduct on the part of the employer. Second, the employer has to have invaded the employee's private affairs without justification. And third, in a way that a reasonable person would see as highly offensive, causing distress, humiliation, or anguish. Some examples of how employers have breached employees' privacy rights, including accessing their bank records or unfairly or inappropriately sending information about the employee to a credit rating bureau. Third, and finally, there is a right for an employee to be free from lies or mistaken information called negligent misrepresentation. This right arises most often with misstatements during the hiring process, inaccurate information about promotional opportunities, or inaccurate advice about pension rights or other complicated benefits. The key point to this tort is whether the employee first made a different choice as a result of the misinformation given to them, and second, are they worse off as a result of having made that choice? The legal term for this is detrimental reliance. Those were three examples of the types of claims that employees may have, or the types of rights employees may have, aside from their right to notice and severance. If you think that your employer has committed one of these wrongs or has acted wrongly in some other way, a lawyer at Nelligan O'Brien Payne can assist you. I'm Chris Rootham, a lawyer at Nelligan O'Brien Payne in the labor and employment law groups.